De la Torre v. Cumlic. Facts: Rolando P. de la Torre filed an instant petition for certiorari seeks the nullification of resolutions issued by the Commission on Elections allegedly with grave abuse of discretion amounting to lack of jurisdiction in a case for disqualification filed against him before the Cumlic. The first assailed resolution dated May 6, 1995 declared de la Torre disqualified from running for the position of mayor of Cavinti, Laguna in the May 8, 1995 elections, citing as the ground therefore, Section 40 of RA 7160, i.e. those sentenced by final judgment for an offense involving moral turpitude or for an offense punishable by 1 year or more of imprisonment within 2 years after serving sentence. The other is the denial of the motion for reconsideration. Issue: whether the crime of fencing involves moral turpitude. Held: a crime involving moral turpitude is one which is an act of baseness, vileness, or depravity in the private duties which a man owes his fellow men, or to society in general. Contrary to the accepted and customary rule of right and duty between man and woman, or conduct contrary to justice, honesty, modesty, or good morals. The elements of the crime of fencing are: a crime of robbery or theft has been committed, the accused who is not a principal or accomplice in the crime of robbery or theft, buys, receives, possesses, keeps, acquires, conceals, sells or disposes, or buys and sells, or in any manner deals in any article, item, object or anything of value, which have been deprived from the proceeds of the said crime. The accused knows or should have known that the said article, item, object or anything of value has been derived from the proceeds of the crime of robbery or theft, and there is, on the part of the accused, intent to gain for himself or for another. Moral turpitude is deducible from the third element. Actual knowledge by the fence of the fact that property received is stolen displays the same degree of malicious deprivation of one's rightful property as that which animated the robbery or theft, which, by their very nature, are crimes of moral turpitude. Thus, the Cumlic did not err in disqualifying the petitioner on the ground that the offense of fencing of which he had been previously convicted by final judgment was one involving moral turpitude. Moral turpitude is deducible from the third element. Actual knowledge by the fence of the fact that good morals, the duty not to appropriate, or to return anything acquired either by mistake or with malice is so basic it finds expression in some key provisions of the Civil Code on Human Relations and Solutio Indebiti. Verily, circumstances normally exist to forewarn, for instance, a reasonably vigilant buyer that the object of the property received is stolen displays the same degree of malicious deprivation of one's rightful property as that which animated the robbery or theft, which, by their very nature, are crimes of moral turpitude. And although the participation of each felon in the unlawful taking differs in point in time and in degree, both the fence and the actual perpetrator/s of the robbery or theft invaded one's peaceful dominion for gain, thus deliberately reneging in the process private duties they owe their fellow men or society in a manner contrary to XXX accepted and customary rule of right and duty XXX, justice, honesty XXX, or sale may have been derived from the proceeds of robbery or theft. Such circumstances include the time and place of the sale, both of which may not be in accord with the usual practices of commerce. The nature and condition of the goods sold, and the fact that the seller is not regularly engaged in the business of selling goods may likewise suggest the illegality of their source, and therefore should caution the buyer. This justifies the presumption found in Section 5 of PD number 1612 that mere possession of any goods, XXX, object or anything of value which has been the subject of robbery or thievery shall be prima facie evidence of fencing, a presumption that is, according to the court, reasonable, for no other natural or logical inference can arise from the established fact of XXX possession of the proceeds of the crime of robbery or theft. All told, the Cumlic did not err in disqualifying the petitioner on the ground that the offense of fencing of which he had been previously convicted by final judgment was one involving moral turpitude. Anent the second issue, where petitioner contends that his probation had the effect of suspending the applicability of Section 40 of the Local Government Code. Suffice it to say that the legal effect of probation is only to suspend the execution of the sentence. Petitioner's conviction of fencing, which we have heretofore declared as a crime of moral turpitude and thus falling squarely under the disqualification found in Section 40, subsists and remains totally unaffected notwithstanding the grant of probation. In fact, a judgment of conviction in a criminal case ipso facto attains finality when the accused applies for probation, although it is not executory pending resolution of the application for probation. Clearly then, petitioner's theory has no merit. Magno v. Kumlik. Facts: this is a petition for the disqualification of Nestor Magno as mayoralty candidate of San Isidro, Nueva Ecija during the May 14, 2001 elections on the ground that petitioner was previously convicted by the Sandiganbayan of 4 counts of direct bribery. Thereafter, petitioner applied for probation and was discharged on March 5, 1998 upon order of the Regional Trial Court of Gapan, Nueva Ecija. The Kumlik ruled that petitioner was disqualified from running for the position of mayor by virtue of Section 12 of BP 881. Crime involving moral turpitude shall be disqualified to be a candidate and to hold any office, unless he has been given plenary pardon, or granted amnesty. According to the Kumlik, inasmuch as petitioner was considered to have completed the service of his sentence on March 5, 1998, his 5-year disqualification will end only on March 5, 2003. The MR was denied the by Kumlik. Issue 1. Direct bribery is a crime involving moral turpitude. Held yes ratio. Petitioner argues that direct bribery is not a crime involving moral turpitude. Likewise, he cites Section 40 of RA 7160, which he claims is the law applicable to the case at bar, not BP 881 or the Omnibus Election Code as claimed by the Kumlik. Said provision reads Section 40. Disqualifications. The following persons are disqualified from running for any elective local position: those sentenced by final judgment for an offense involving moral turpitude or for an offense punishable by 1 year or more of imprisonment within 2 years after serving sentence. Petitioner insists that he had already served his sentence as of March 5, 1998 when he was discharged from probation. Such being the case, the 2-year disqualification period imposed by Section 40 of the Local Government Code expired on March 5, 2000. Thus, petitioner was qualified to run in the 2001 elections. Moral turpitude is an act of baseness, vileness, or depravity in the private duties which a man owes his fellow men, or to society in general. Contrary to the accepted and customary rule of right and duty between man and woman, or conduct contrary to justice, honesty, modesty, or good morals. Not every criminal act, however, involves moral turpitude. It frequently depends on the circumstances surrounding the violation of the law. In this case, we need not review the facts and circumstances relating to the commission of the crime, considering that petitioner did not assail his conviction. By applying for probation, petitioner in effect admitted all the elements of the crime of direct bribery. The offender is a public officer. The offender accepts an offer or promise or receives a gift or present by himself or through another. Such offer or promise be accepted or gift or present be received by the public officer with a view to committing some crime, or in consideration of the execution of an act which does not constitute a crime but the act must be unjust, or to refrain from doing something which it is his official duty to do, and the act which the offender agrees to perform or which he executes is connected with the performance of his official duties. Moral turpitude can be inferred from the third element: the fact that the offender agrees to accept a promise or gift and deliberately commits an unjust act or refrains from performing an official duty in exchange for some favors. Denotes a malicious intent on the part of the offender to renege on the duties which he owes his fellow men and society in general. Also, the fact that the offender takes advantage of his office and position is a betrayal of the trust reposed on him by the public. It is a conduct clearly contrary to the accepted rules of right and duty, justice, honesty, and good morals. In all respects, direct bribery is a crime involving moral turpitude. Issue: what law should apply in this case? Held local government code ratio. It is the second sub-issue which is problematical. There appears to be a glaring incompatibility between the 5-year disqualification period provided in Section 12 of the Omnibus Election Code and the 2-year disqualification period in Section 40 of the Local Government Code. It should be noted that the Omnibus Election Code was approved on December 3, 1985, while the Local Government Code took effect on January 1, 1992. It is basic in statutory construction that in case of irreconcilable conflict between two laws, the later enactment must prevail, being the more recent expression of legislative will. Legis posteriors priori's contractarius abrogant. In enacting the later law, the legislature is presumed to have knowledge of the older law and intended to change it. Furthermore, the repealing clause of Section 534 of RA 7160 or the Local Government Code states that all general and special laws, acts, city charters, decrees, executive orders, proclamations and administrative regulations, or part or parts thereof which are inconsistent with any provisions of this code are hereby repealed or modified accordingly. In accordance therewith, Section 40 of RA 7160 is deemed to have repealed Section 12 of BP 881. Furthermore, Article 7 of the Civil Code provides that laws are repealed only by subsequent ones, and not the other way around. When a subsequent law entirely encompasses the subject matter of the former enactment, the latter is deemed repealed. The intent of the legislature to reduce the disqualification period of candidates for local positions from 5 to 2 years is evident. The cardinal rule in the interpretation of all laws is to ascertain and give effect to the intent of the law. The reduction of the disqualification period from 5 to 2 years is the manifest intent. Therefore, although his crime of direct bribery involved moral turpitude, petitioner nonetheless could not be disqualified from running in the 2001 elections. Article 12 of the Omnibus Election Code must yield to Article 40 of the Local Government Code. Petitioner's disqualification ceased as of March 5, 2000, and he was therefore under no such disqualification anymore when he ran for mayor of San Isidro, Nueva Ecija in the May 14, 2001 elections. Unfortunately, however, neither this court nor this case is the proper forum to rule on the validity of Sonia Lorenzo's proclamation and the declaration of petitioner as the rightful winner. Inasmuch as Sonia Lorenzo had already been proclaimed as the winning candidate, the legal remedy of petitioner would have been a timely election protest.